I love saying "I told you so." Just a couple days, I reported on the United Methodist Church's General Judicial Council that was reviewing a case pertaining to whether or not paragraph 2549 in their book of discipline could be used as a disaffiliation provision. And I said they were going to announce that it couldn't be. Once upon a time, they had paragraph 2548.2 that allowed for disaffiliations from the UMC. In 2019, they approved a new paragraph, 2553, which they then used, the Judicial Council used to cancel out to 2548.2 for reasons that were stupid. I think that's a category, legally, stupid. They said because there was a new provision that canceled out the old, as though you can't have two provisions for something. And then 2553 expired at the end of last year, so they started using 2549, which closes a church, to effectively allow churches to disaffiliate. And conferences like South Carolina use that before 2553 ended and after. There are many other conferences there are probably 5 to 10 other conferences that have continued to allow churches to disaffiliate through that. But Kentucky and Alabama, West Florida, both before allowing it to be used, put it to the Judicial Council. Can we use it this way? And I was right. In decision number 1512, which was published widely yesterday, they said, no, it cannot be used that way. Petition for declaratory decision from the Alabama-West Florida Annual Conference regarding the meeting, application, and effect of 2549 of the Book of Discipline, 2016, as it relates to a policy, process, or method for the UMC to exit or separate from the denomination. And this is not a long document. I'll just read it to you because it's important to understand those with whom we disagree, right? Connectionalism is a bedrock principle of the United Methodist Constitutional Polity, and the trust clause is its foundational element. Disaffiliation is a radical departure from connectionalism, and therefore church property can be released from the trust clause only to the extent authorized by church law. So connectionalism is a traditionally Wesleyan concept that says that all these churches are connected in a common covenant. And when they say that the trust clause is the bedrock of that, then what that betrays is they understand covenant to be something that's maintained only through coercion. So that is not an understanding of connectionalism that all Methodists have always agreed upon, or that maybe even a majority even agree upon right now. We can only have connectionalism if the denomination holds all the property in trust and can relieve you of it or constrain you to it against your will. If that's what your connectionalism is based off of, that might not be good. With the expiration and deletion of paragraph 2553, the postponed 2020 General Conference effectively removed from the Book of Discipline in 2016, hereafter just called Discipline, the only pathway for disaffiliation of local churches. Except for the General Conference, no body or entity in the church has the power to reinstate or replicate paragraph 2553 or adopt legislation, policies, guidelines, rules, or regulations authorizing the departure of local churches. Any such action, plan, or attempt to do so intrudes upon the exclusive prerogative of the General Conference and is unconstitutional, null, and void. Further, paragraph 2549 cannot be construed or used as legislation permitting the gracious exit of local churches because it applies to church closure and the sale of property, not disaffiliation. Any application of paragraph 2549 to that end would be a misapplication of church law. So, of course, they're not bringing up 2548.2 at all, which before 2553 had been around for decades as a disaffiliation provision for an amicable. They said, from now on, we're not having a gracious exit. There are no exits from the United Methodist Church. We're connectional, and that's now code for you have to stay. You cannot leave. We're all in this together, even if we don't want to be anymore. You have to stay. And you can leave, but you're going to have to leave your stuff with us. That's effectively what it's saying. Let's see what their statement of facts is. During the session of June 17th, 2024, the Alabama-West Florida Conference, a motion was made to request a Judicial Council declaratory decision regarding the meaning, application, and effect of 2549 of the discipline as it relates to a policy, process, or method for the United Methodist churches to exit or separate from the denomination, and the vote passed by 81%. This was before they understood the implications of this. They said, yeah, it's reasonable, let's figure out if it's legal, but then that made it so that they couldn't have any conversations about disaffiliation, and there were a ton of churches that still wanted to disaffiliate, but then the leadership said, well, you guys voted to put this to the Judicial Council, so we can't act on it until we get a decision back. So they, without them understanding, got them to vote on a provision that effectively kept them all in, whereas other annual conferences have been allowing these disaffiliations under 2549. They got hoodwinked into staying. That's my language. The Judicial Council has jurisdiction under paragraph 2610.1 of the Book of Discipline, hereinafter discipline. So here's the analysis and rationale. Connectionalism is, quote, a bedrock principle of the United Methodist constitutional polity. True. A foundational element of connectionalism is the trust clause, a legal concept predating the founding of the UMC in 1968 and tracing back to our Wesleyan origins, which ensures not only that the property will be used solely for purposes consonant with the mission of the entire denomination as set forth in the discipline, but also protects the open itinerancy so that each person serving under appointment, without regard to race, ethnic origin, gender, color, disability, marital status, or age. The Judicial Council has already held an annual conference and may not disaffiliate without general conference action. That doesn't make... The Judicial Council cannot hold an annual conference. May not disaffiliate with... Here we hold that the local church may not disaffiliate without general conference action. So if they were honest, what they would do is they would say 2548.2 was ruled out because of the presence of 2553. Now 2553 is not in effect, so 2548.2 is now back in effect, and we can operate under that. But they're not doing that. Rather, this is the first time, I think, that they have a book of discipline that does not allow anyone to exit for any reason. So now I should say individual churches can still negotiate with annual conference leadership to disaffiliate, but that's contingent upon the annual conference being amenable to that. Right now, with huge budget shortfalls, they're not generally open to that notion. Rather, they're much more likely, and we've already seen and will continue to see all over the place, churches that are liquidated so as to get the assets and money to undergird the annual conference structure. You're going to see that all over the place more and more. Paragraph 2549 sets out a detailed process and procedure for the closure of a local church. One aspect of that process is that, quote, the local church no longer serves the purpose for which it was organized or incorporated. The local church is no longer used, kept, or maintained by its membership as a place of divine worship of the UMC, end quote. What is being proposed here is that the opposite of the intent of 2549. What is being proposed is replacing 2553 with 2549 as an alternate way for disaffiliation. Paragraph 2549.4 discusses, quote, developing a plan for the transfer of local church membership, end quote, to another UMC. The proposed use of paragraph 2549 contradicts the clear intent of 2549 by taking members and properties from the UMC and continuing religious activities as a new entity, no longer a part of the UMC denomination. It clearly states in 2549.23b, quote, all real and personal property, tangible and intangible property of the local church shall immediately vest in the annual conference board of trustees, who shall hold said property in trust for the benefit of the annual conference. What I take this to be saying is this is a provision that's made for the good of the UMC. How is this for the good of the UMC to let these properties go back to these people who don't want to be with us? 2549.4 discusses developing a plan for the transfer of the local church membership to another UMC. So that's not happening. You're not transferring the membership. And the assets, it's saying, are not going to the Board of Trustees. Technically speaking, the way that this has been done and understood, and I don't think it's necessarily dishonest, if the language is, it is no longer serving the purpose that it was originally designed to, the purpose would be serving faithfully alongside other United Methodists. They're not happy to do that anymore. There's a new purpose, so let them go. And then the property does transfer to the Board of Trustees, which then immediately transfers the property to this new congregation. So that's how they've been doing it and understanding it. And they're saying this goes against the clear intent of this. They're reading intent into this that I don't think is there. I don't think it implies any intent. The intent is what it says to take a church building or assets and separate them from the United Methodist Church through the Board of Trustees of the annual conference. And that's what they have been doing. So I don't think that makes much sense. The use of paragraph 2549 in this way is another failed attempt to circumvent the trust clause, a hallmark of United Methodist polity. So the trust clause. The problem is that the UMC subverted the trust clause. The trust clause was put there to defend the original doctrine, discipline, and spirit with which we first set out. They subverted all of that, inverted all of that, reversed all of that, and now they're using the trust clause to enforce a new orthodoxy that flies in the face of the old orthodoxy, and they're being ungracious about it. So whereas conservatives were willing to let liberal progressives go if their consciences couldn't be on board, progressives in charge now are saying, you can go, leave your stuff. So if you imagine an abusive cohabitating couple, and the male says, you can go, but leave all your clothes, leave all your money, you can live out on the street now. That's what the United Methodist Church is doing to conservative congregations now. They're removing any means of exiting with your resources. Paragraph 2549 does not give an annual conference disciplinary authority to close a local church and then provide all of the assets to the exiting congregants as proposed by the Alabama-West Florida Conference. Paragraph 2501 clearly states that the trust clause, quote, reflects the connectional structure of the church by ensuring that the property will be used solely for the purposes consonant with the mission of the entire denomination, as outlined in the discipline. The proposed use of 2549 contradicts the clearly expressed intent of paragraph 2501 in the discipline and violates the Constitution. Paragraph 2549.3a can only be used after these have been followed. This is longer than I remembered, but the notion here is you cannot have a local church in the United Methodist Church that does not represent the United Methodist Church. And so you have to have a means of, they've removed a means of local churches separating themselves. Now they're removing the means of an annual conference separating these bodies that are no longer in conformity with them. Rather, they can still do it, but not for liberal conservative stuff. They can still sell. I mean, like what this is saying now is like if they start refusing to do infant baptism, or they stop preaching sanctification or something, that the annual conference, they can separate these people and their assets from them. But I think it's saying you cannot allow them to have the property. So this is turning something that was morally neutral and making it a vindictive thing. You have to separate these people from their assets. You have to use this in a way that is selfish for the annual conference. Implying that logic is really nasty. I feel sorry for them. I should say, when they put this new Judicial Council together, it was overtly done in a way to stack it with people who were sympathetic with the progressive far left. This was done on the floor of General Conference, and you saw all kinds of hostility and overt political maneuvering to then create this body that would rubber stamp whatever the progressive leadership wanted to do. This isn't a surprise. It is an embarrassment. Anyone who wants to take the United Methodist Church seriously as any kind of arbiter of truth, I just think this is so overtly self-serving. And in fact, I mean, they're making the case here, it has to be self-serving. It's hard to see how this is at all connected to a biblical or Christian way of life. And so conservatives, there are still a ton of conservatives and conservative churches trapped within the United Methodist Church that now the doors have been closed and they've said you can leave, but you can't take your stuff with you. To that end, here's a statement put out by Eric Grayson. Oh, sorry.
Methodist movement was all about establishing new. It is my privilege and honor to share with you and anyone who is interested that the Global Methodist Church is committed to being a church planting movement. From our earliest days, the Methodist movement was all about establishing new congregations and new places where people could worship the Lord and be transformed by the gospel of Jesus Christ. As a renewal movement of Methodism, we're getting back to our roots of equipping lay people to help establish new places of worship.
So this is pretty openly in conjunction. South Carolina has been using paragraph 2549. Now they can't. There is no way out. You have the Global Methodist Church now saying, hey, if you're not happy in the UMC, he didn't say it like this, but this is what's behind it. If you're not happy in the UMC, you don't have to wait on clergy to plant a church. You, laity, can come together and plant a church, and then we can you can come into the GMC, and we're happy to empower you to do that. But this is, I hope this is welcome. It's saying you're not trapped. You might feel trapped. You can leave anytime and start your own community, and we're going to help you, which I think this is a wise and helpful thing to do. There was also, we don't have time to go over it, but there was the write-up from Heather Hahn, Church Court season of church exits is over. I think this is the new Judicial Council here. Yeah, it is. And so it has all of them listed out there. You can read that. You should find the link in your show notes. And so you can read that at your own time if you want to. Is there anything else I want to say? It's already 8 o'clock, and my brother DA is hopefully about to be on. I didn't even open Zoom for me to bring that up. So hopefully he's waiting on me whenever I get up. I'll clip this up and put it out later, and I want to hear your thoughts on maybe I've dismissed 2549 ruling from the Judicial Council wrongly. Maybe they do have some good reasoning here, but I'm pretty sure I'm right. I'm pretty sure everybody knows that this is just a self-justifying measure, and it's not good. So I'm interested to hear everybody's thoughts. There are a lot of people who are smarter than me on this stuff, but I think it's pretty self-evidently not good.